We will start the hearing immediately this announcement is completed. May I remind everyone to keep their microphones and cameras muted, except when speaking, as the technology will automatically place anyone making a noise onto the main screen, so inadvertent coughs or rustles may disturb the rhythm of the hearing. Please also remember that the inquiry is recording the proceedings, and others attending are prohibited from doing so. My name is Christine Smith, and I am the hearing manager today and every Tuesday and Thursday. My colleague, Lee Hughes, will be here on Mondays, Wednesdays and Fridays. You have my number to contact me should there be any issues you wish to raise with the inquiry team or relating to the technology. We shall aim to deal with any problems as quickly as possible. The hearing will begin very shortly. Chair, I believe everyone is ready to begin.
Thank you, Ms. Smith. Good morning, everyone, and welcome to day 4 of this public hearing. Ms. Hill.
Good morning, Chair and panel. Thank you for agreeing to sit early this morning. As you know, there is an application to be made by Ms. Gallagher on behalf of several of the call participants. Please go ahead, Ms. Gallagher.
Thank you very much, Chair and panel. May I just confirm I can be seen properly and you can hear me? Thank you. Will Chair and panel and your team, we are very grateful to you and to your team, STI and CTI, for making time this morning in what we recognise is already a jam-packed schedule to hear this application. And I am asked to make it on behalf of my own client, the Centre for Women's Justice, also on behalf of Parents Against Child Exploitation, PACE, and the 2 individuals represented by Howe & Co, Maggie Oliver and John Wedger. Now, as Ms Sharpling said yesterday when questioning Mr Orford in the afternoon, this is a public inquiry, and in the view of those I represent this morning, the applicants, it is right that this issue of profound concern to those who work with victims and survivors is being heard in public and not being dealt with in correspondence, and we're grateful to you for hearing it. We have a limit of 15 minutes to make this application. We've liaised between us to make the most effective use of time, and so you know, we've agreed I will make the joint application, taking approximately 12 minutes. Mr Jacobs is likely to have 2 to 3 minutes to add at the end, and Mr Chapman has already contributed to this joint submission. He may address you very briefly if there are any matters arising. Ms Harrison of Slater and Gordon, Mr Suleiman of Clifford Chance do not seek to address you this morning, but by agreement I'm asked to say the following. You'll be aware from yesterday's letter from Howe & Co that the application made by CWJ, PACE and Howe & Co.'s clients is also supported by Sarah Champion MP, and the concerns it raises therefore have the support of every single national level non-institutional core participant. You will also be aware from yesterday's letter that CSA2, Ms Harrison's client, the only complainant CP in this investigation, in fact the mother of a victim of CSE, although focused on Warwickshire, wholeheartedly shares the concerns we raise regarding the timetabling of this hearing and the absence of voices from victims and survivors who can challenge official narratives provided by institutional witnesses. So, Chair, if I can put it this way, this means that every single core participant in this investigation who is complainant-focused, whether a complainant themselves in the case of CSA2, or an independent individual or an organisation which represents or works with victims and survivors, shares these concerns. And we speak with one voice this morning when addressing you concerning the problems. Now, you may wonder why these problems are being raised on day 4 of a 10-day hearing. But in truth, as you know, Chair, we've been raising these concerns in correspondence and submissions since we first received the draft timetable earlier this year, and the concerns regarding the importance of meaningful involvement of the voices of victims and survivors was a central theme of concern to all of those I represent at the last preliminary hearing in January, when we first heard of the proposal to consider case studies of children in the geographic areas in an attempt to plug the gap, there being only one complainant represented in the geographic areas. And so, Chair and panel, the clients I represent this morning, the applicants, have raised these concerns again and again. And as the hearing is playing out this week, we are seeing the results of what we anticipated all along. And we recognise and thank your team for the efforts they've made to plug the gaps, particularly over the last number of months, and to address the concerns we've raised. But we are before you this morning because the applicants consider these efforts are simply not good enough. And you'll be aware that our concerns were heightened and exacerbated by what occurred on day 2. Now, I intend to address you in 2 parts. First, to outline the problems of concern, and then to turn to potential solutions. So in relation to the problems, the first concerns timetabling. Even with the witnesses on the timetable, the applicants are concerned that it is simply too tight to probe witnesses effectively. And we saw that in day 2. On day 2, we saw 2 complainants give evidence in the morning. We then saw a hot tub of 2 very important witnesses, the academics, Dr. Beckett and Dr. Hallett, in the afternoon. And we then had Sheila Taylor's evidence at the tail end of the afternoon. And all of those I represent are of the view that day 2 was simply far too rushed. And that was most apparent in relation to the evidence of the second victim who gave evidence to you and the evidence of the academics. And in relation to the second victim who gave evidence to you, we were in the bizarre position of having the later part of her evidence rushed through, which resulted in something which my client, the Centre for Women's Justice, found rather ironic, where she was being asked rushed questions about how poor her experience had been of giving evidence at a criminal trial. When questions were being put to her, she wasn't having the opportunity to expand and explain. And we note that overnight, Bristol, one of the local authorities, has written to you to share the concerns which the applicants, Sarah Champion and CSA2, have raised in yesterday's letter. And as noted in particular, that Bristol's legal representatives were of the view that the victims' evidence on day 2 was rushed, and you didn't get to hear from them in a forward-facing case study about their important views on how things could improve in future. And the result of that is, I'm afraid, that those I represent this morning are of the view that the complainant evidence you heard on day 2 was rushed and felt rather tokenistic, and hasn't enabled you to grapple with key issues which will arise on day 9 when it comes to the institutional, national level witnesses. Now, in relation to timetabling, we also think that the academics' evidence was rather rushed, and we then had Sheila Taylor's evidence at the end of the day. And I'm asked to say, and this is a point I make on behalf of the Centre for Women's Justice, Maggie Oliver and John Wedger, that there were particular concerns about the value that was added by Sheila Taylor's evidence, and I'll return to that in a moment. But on day 9, on the timetable, we can see that you have 2 hot tubs listed. You were due to hear from the Home Office, from the Department for Education and the Welsh Government concurrently. That is not a hot tub in the usual sense, where you have 2 witnesses with the same expertise talking about the same issue and being able to bounce ideas around. This is in essence 3 witnesses giving evidence concurrently on hugely important and wide-ranging issues involving 2 government departments and 2 countries. And that has been allocated half a day, which we already think is tight. But our concerns are even more exacerbated when we look at the afternoon of day 9. And we see that you have planned for the afternoon of day 9, first of all, a hot tub of 2 witnesses from Ofsted, 1 witness from the Care Quality Commission, and 2 witnesses from HMIC FOS. And we simply think trying to squash that evidence into less than half a day is unrealistic and will lead to superficial evidence giving and an inability to probe the witnesses effectively. And finally on that day, Gregor McGill of the CPS is also squeezed in. So we think that before you even turn to the important issues we've raised in yesterday's letter regarding the need to hear from other voices and the skewed nature of the evidence on the timetable as it stands, we are profoundly concerned that the time allocated to that important national evidence is simply insufficient. We recognise, of course, that you will also be hearing from Amanda Naylor of Barnardo's at the tail end of Wednesday, 30th of September. Again, not even a half-day slot. So we think it is already too tight, even with the witnesses you have listed. But more profoundly, when we look at the list overall, the applicants have a grave concern that there is what they've described in the headline to the Howe & Co letter yesterday, a profound imbalance in the evidence. we have a situation where on the timetable, when you look at the national level evidence, you are hearing from a large number of the national level institutional core participants. But you are not hearing from a single one of the national level non-institutional core participants. You are not hearing from a single one of those who at a national level represent and work with victims and survivors. And we're of the view that although you did hear from Sheila Taylor and you will be hearing from Amanda Naylor of Barnardo's, that evidence simply does not plug this gap. As we made clear in the letter, we note that Ms. Taylor works with and provides services to institutions. Much of her witness statement and indeed her evidence focused on pointing out the benefits of her organisation's training services. Barnardo's similarly is commissioned by institutions to do work. And we recognise the importance of Barnardo's evidence, but you still have a fundamental gap and a fundamental skew when it comes to the evidence. And when you think of someone from the outside looking at this hearing, they may well ask, why are we hearing from one side and not the other? Why are we hearing from the institutions? Why are we hearing from witness after witness with corporate speak and assertions about how well they are doing in the fight against CSE without the ability to really probe and push back against them? And in relation to timetabling, we also note this, which is an important point. We are very conscious that when you look at other strands of this inquiry, large allocations of time have been made available to other topics relative to this. You've got a situation where 3 weeks were allocated to an investigation concerning 2 male Catholic boarding schools. And all of those I represent this morning are profoundly concerned that only 2 weeks has been allocated to the issue of CSE in organised networks, described by the Children's Commissioner as affecting every city, town and village in the UK, and also described as the biggest current child sexual abuse issue in the UK today. And one of those I represent said to me this morning, isn't this a case of some victims are more important than others? There are some more important victims than others, and is this even a class issue? Now, I raise that because it's important that you're aware of the perception that's been given with a strand of the inquiry which is 2 weeks long, where you don't hear from a single national level victim and survivor focused witness or core participant, and you only have one single complainant who's represented throughout the entire strand. So on timetabling, we think there's a profound problem. That's the first problem. Secondly, we think there's a profound problem in relation to the imbalance and the skewed nature of the evidence. And the third problem, which we highlight this morning, relates to a concern regarding black and minoritised ethnic communities and a particular cultural gap. Now, we have raised this. We raised this in correspondence and in submissions to you previously, and we have been told that those concerns will be addressed in the evidence. And indeed, you saw an attempt to do that with Sheila Taylor on day 2 when she was asked about the Angelou Centre statement. And her frank response was that she hadn't read it. And she then gave a very generalised answer in response to a question about BME, where she referred to LGBTQ issues and other issues. And it seems to us that in a situation where you've got a 2-week hearing, we understand, although we're not certain, that leaving aside the complainants whose identities are protected, you will be hearing from a large range of white witnesses. We are deeply concerned that you are not hearing from any witnesses with particular expertise in relation to black and minoritised ethnic victims of CSE, and that is a profound gap, and we are deeply concerned about it. They, in brief, are the key problems which we wish to address you on today. There are other problems which we recognise arising from the way in which this strand of the inquiry has been approached, but we don't raise those before you today simply because we recognise we are where we are and we're mid-hearing. But when it comes to these particular issues, the timetabling problem, the imbalance, and the absence of an effective way of looking at BME issues, we think there is a ready way to address this. And we have, in our letter yesterday, indicated a range of potential solutions which you could look at. And Chair, I make this point about potential solutions, recognising that, of course, you and your team will have additional information. You will know about witness availability and other topics. So we make them as a range of proposed solutions. Our core point is there is a fundamental problem here. It must be addressed, and the credibility of this investigation is at stake as matters stand. Now, may I address first a possible solution which was carved out earlier in the week, and that was the decision on day 2, mid-hearing, to agree to adduce, at the end of the day, additional national level evidence. So at the very end of the day, a reference was made to a large number of individuals, including those I represent this morning, and extracts from their statements were then to be uploaded to the website. Now, this indicates precisely the problem, because first of all, you look at the inquiry's public feed. The inquiry's Twitter feed on that day said, now we're hearing about some additional evidence, made no reference to what that evidence was. We went onto the website that evening on day 2 to see where this published evidence was. Nowhere to be seen by 11:30 p.m. on day 2. Nowhere to be seen by 8 a.m. on day 3. It appeared at some point yesterday during the hearing, and the format in which it appeared gives us profound concerns from an open justice perspective, because the way it's appeared is without any names. It doesn't say, here's the evidence of Harriet Wistrich, here's the evidence of Maggie Oliver. It simply gives a list of INQ numbers. It looks like an extract from the log tables. It doesn't have an index. The index which is provided, and which says that it is the material that was adduced on day 2, is the old list. It simply lists the evidence of those who were always due to give evidence. And my clients see that as insulting, and it makes quite clear that this was an afterthought, a tack-on, and not an appropriate way of dealing with national-level, non-institutional core participants, and not a way of dealing with this profound gap in the national evidence. So we say that solution isn't good enough. In terms of the range of solutions we set out in the letter, may I just flag, in particular, 3 that we think should be considered seriously. The first is we ask that additional time be scheduled to allow this hearing to run into a 3rd week, allowing more time to probe the national level witnesses in particular who you have rammed into day 9, and allowing an opportunity for other voices to be heard. So we ask that you allow extra time, and I'm asked to advance that you allocate a full additional week and you find time to do it. If a full week cannot be found, at the bare minimum, we ask that day 10 in this hearing, the last day of evidence, when we'll all be here, albeit virtually, we ask that instead of hearing closing submissions on that day, that be converted to an additional day for evidence. It will allow extra breathing space for those day 9 witnesses to be properly probed, so we don't have a rush in the way that we did on day 2, with your counsel having to make substantial efforts to get through a huge volume of material and long topic lists in a time which is simply too tight for it. And closing submissions can then be made by those who wish to do it on a later day. Now, in other strands of the inquiry, you've done this. You've done this in a wide range of other inquiries where you've needed to find an additional day because a witness overran, or you've needed to find an additional day or indeed an additional week, as you did in the other religious institution strand, when technical problems meant a 2-week hearing needed to be converted to a third week. So we ask you give us a 3rd week. If you cannot give us a 3rd week, at least give us day 10. Second request is that one or more of our clients are called, even in a hot tub, to provide a counterpoint to the institutional evidence and give us an ability to contrast the published policy, the stated practice, the corporate speak and the assertions with the reality of practice for those on the ground who work directly with victims and survivors. And we can deal with the detail of who they may be in writing later rather than taking up time this morning. But we ask that you do hear from at least one of the national non-institutional core participants. And thirdly, we ask that you consider hearing from those with particular expertise in relation to BME issues. And that can be done ideally through someone being called, like Rosie Lewis from the Angelou Centre. But at a minimum, you should read their evidence into the record. It's not good enough to upload it to the website a day late under an INQ number which nobody can follow. This is a public hearing, as Ms Sharpley said yesterday, and it is imperative, we say, that this material is at the forefront and that the inquiry does what the inquiry has always said it will do, and have victims and survivors at the core of its work. Now, for those reasons, we all say to you this is a profound problem. We say that the inquiry has simply got to grapple with this. We recognise ideally this would have been done far earlier, potentially at the January hearing, for example, although we didn't have the timetable then, or earlier. But we have listened to reassurances that this will be dealt with. But as the hearing is playing out, I'm afraid none of us feel that this inquiry, as currently constituted and as currently proceeding, is doing justice to the victims and survivors of the scourge of CSE within organised networks. And we think change is necessary. We've been constructive and suggested some proposed ways that you could change. We're in your hands as to how you do it, but something simply must be done. And I ask you that on behalf of all the applicants this morning. Thank you.
Very, very good.
Thank you, Ms Gallagher. Mr Jacobs, you will have to be brief.
Yes, I support the points that have been made by Ms Gallagher, particularly in relation to the proposal for Day 10. John Wedger and Maggie Oliver, my clients, don't wish to cause any inconvenience to the inquiry and are appreciative of the work that's been undertaken by the legal team in investigating the matters that they've devoted their lives to confronting and exposing. However, they and all the other non-institutional national level court participants maintain that there's a fundamental imbalance in the evidence within this investigation, and our concerns are shared by Bristol City Council, for whose support in this application we're grateful, and we invite other institutions who have a view on this matter to indicate their view at the end of this application. Chair, through How & Co, Mr. Maggie Oliver and John and my other client have raised the matter with inquiry lawyers back in April of this year. In correspondence, Mr. Enright drew the inquiry's attention to the lack of any proposal to hear from a countervailing alternative perspective at the national level and to respond to and contrast with those witnesses on the then draft timetable. He made the point that although complainants would be providing a non-institutional voice, those witnesses do not have a detailed knowledge of institutional proceedings and failings. Chair, those who are giving evidence for institutions are the main corporate directors, policymakers, senior police officers and strategic directors. They will assist the inquiry from a purely institutional perspective, but they are not involved with victims of CSE on a daily basis, if at all. Maggie Oliver, by contrast, and her staff at the Maggie Oliver Foundation have supported and assisted 1,522 survivors of CSE between June 2019 and July 2020. Mr. Fledger is in contact with approximately 15 to 20 victims every day. That is what makes their evidence so important, and that is why this evidence should be heard. You'll recall on day one that you heard submissions from Ms Gallagher QC to the effect that there is a significant gap between the evidential picture presented by the institutions and the experiences on victims of CSE on the ground. This is a matter which the inquiry must, at the very least, explore during the hearing if its findings and conclusions are to have an evidential basis, a proper evidential basis. For many years, the public at large, the face and voices of exploited children has been Maggie Oliver. The BAFTA award BBC drama Three Girls, inspired by Ms Oliver's work, shocked the nation into awareness of sexually exploited children and the failure of the police and others to protect them. And similarly, my other client has 1 million new media followers who will find it impossible to understand why you will hear evidence from police forces who failed children, but not expert commentators and campaigners like him. It's neither realistic nor reasonable for members of the public to be expected to access extracts of non-institutional, national-level court participant online statements from the inquiry website. Chair, it is relevant to note that many CSE victims will no doubt be following these proceedings. They may also struggle to understand why those who can actually inform the inquiry of their plight have not been called upon to do so. With the great respect, my clients say that neither Ms Taylor nor Bernardes have the necessary independence from institutions to present the case from the perspective of the ongoing victims. In the event that the inquiry accedes to our application, and is able to call evidence from non-institutional national level court participants on day 10 or otherwise, I would suggest that both my clients give evidence together using the hot tub procedure. Chair, you were faced with similar submissions in the Nottinghamshire Council investigation. That investigation was moving in the wrong direction because the accounts of many victims were not going to be heard. However, the issue was raised with you, and by the end of the investigation, you had directed that the summaries of all of the victims' accounts should be read into the record. Chair, the institutional witnesses did not dominate the proceedings in Nottingham because there was an evidential counterpoint. The same consideration should apply here, particularly as CSE is an ongoing and evolving threat. I therefore ask that you allow the application that is now before you to permit evidence to be heard from the non-institutional national level court participant witnesses, and thereby ensure that not only is the investigation conducted fairly, but that it is perceived to have been conducted. Chair, I've endeavoured to deal with my points quickly. I hope that you could hear me and take them into account.
Thank you, Mr. Jacobs. We'll now hear from Ms. Hill.
Thank you, Chair. You've heard submissions on the time allocated to this hearing and on the balance of the evidence being heard. We've also received submissions, Chair, as you know, from Bristol City Council in writing, and they agree with the need for the inquiry to hear all evidence from independent, non-institutional witnesses, but that witnesses were under too much pressure of time. Chair, I'll deal briefly, if I may, with each of these groups of submissions in reverse order. Dealing first of all with the submission about the pressure of time on day 2. Chair, you'll be fully aware of the pressures that were in place on that day. We understand the submission that is made by Bristol City Council about the suggestion that CSA 12 and CSA 371 give evidence about their proposals to improve responses to those affected by CSE. That hadn't been something in their witness statements or raised on the topics lists, but we are content to send some further suggestions, some further requests to those witnesses to see if they feel able to provide further written evidence on those topics. As far as the 2 academic witnesses are concerned, they have said already that they will provide further evidence in writing, and their statements and much of the underlying evidence has already been adduced and will be published on the inquiry's website. On the wider question of balance, Chair, you'll be aware that the broad purpose of the investigation is to obtain evidence and make recommendations in respect of ways in which institutions work to protect children from child sexual exploitation by organised networks. In order to explore this, Chair, the selection has been made of 6 geographical areas to examine in detail, as I explained in my opening, and the inquiry has requested evidence from the institutions in those areas. It is important that that evidence is tested properly, and this is why we have devoted a whole day to each of those areas. The inquiry is seeking to test the institutional evidence by counsel to the inquiry questioning those witnesses who give oral evidence, by seeking evidence from victims and survivors in those areas, in conjunction with a number of court participants and their representatives, and obtaining evidence from third sector and campaigning groups in these areas, again following suggestions from the court participants, which is then being used to test the evidence of institutional witnesses. Examples of that include the Angelou Centre, Changing Lives, the EYST, the Children's Society, and Voices from Care in Cameroon. And also identifying, as you know, Chair, a number of specific cases involving individual children in each of these areas in order to test the institutional evidence and examine whether their policies and procedures are replicated in practice. We are mindful of the need to ensure that the voices and experiences of victims and survivors are heard by the inquiry. And to this end, Chair, as you know, the inquiry encouraged victims and survivors from the 6 relevant areas to give evidence. It's perhaps understandable that the inquiry was unable to identify any victim or survivor from one of these areas who could give evidence on the themes we are considering, given the very contemporaneous focus of this investigation. There would have been significant safeguarding issues if the inquiry had identified witnesses who were able to give contemporaneous evidence of their ongoing or very recent experiences and wish to invite them to provide evidence. However, Chair, as you know, you will hear in-person evidence from CSA 2 in relation to Warwickshire on day 5, and she will give her perspective as the mother of a sexually exploited child. You'll also recall that we were able to refer to the experiences of several victims and survivors in our opening. and the inquiry has heard powerful evidence from CSA 12 and CSA 371. These accounts are from different geographical areas to the 6 under consideration, but we hope that they have nevertheless provided you and the panel with an appropriate context for the area-specific evidence. The inquiry has also sought evidence from a wide range of non-institutional witnesses. The volume of evidence gathered means that it would simply not have been possible to call all of them to give live evidence, and we have selected 5, Dr. Beckett, Dr. Hallett, Sheila Taylor of the NWG, Vicky McKenna of Catch-22 and Amanda Naylor of Barnardo's. These selections were based on a range of factors, including the relevance of their written evidence to the investigation's stated themes. In addition, we've taken into account the fact that non-institutional CPs are already represented at the inquiry, and so are able to suggest questions for witnesses via the Rule 10 process and make opening and closing statements. This provides them with an opportunity to bring their perspective to bear on the evidence that you will hear. Much of the remainder of the non-institutional witness evidence has or will be published, including the relevant parts of Ms Gallagher and Mr Jacobs and Mr Chapman's client statements. It is not our position that this was a last-minute decision. It is understood that there has been correspondence indicating that the inquiry had proposed to adduce that evidence. Adducing it and publishing it in that way is no reflection on the weight which should be given to the evidence, and indeed we will take steps to ensure that where appropriate, relevant parts of it are put to the institutional witnesses. And no doubt those responsible for the website will have heard the submissions that have been made about the way it is portrayed at the moment. Adducing evidence by publishing it is an important way of the inquiry ensuring that the evidence is available to both you, Chair, and the members of the public who are following these proceedings. And that evidence will, of course, be available to you in the course of writing your report. You've obviously heard submissions, Chair, about reading some evidence from the witnesses who are represented. One other suggestion that we invite you to consider is whether or not to use some of the time that might be made available on the days where there are only 2 in-person witnesses, namely today and Tuesday or day 7. If you consider it appropriate, Chair, to use that time to read some evidence, you may consider whether reading the timelines that have been prepared about the individual children in each area would be a good use of time and would be an appropriate and proportionate way of enabling the lived experiences of those children in the investigation selected areas to be given more prominence. In relation to the suggestion that further witnesses be called to give oral evidence, of course, Chair, this is a matter for you. You will, of course, need to take into account the logistical difficulties of doing so, especially in the context of a remote hearing, but ultimately it is a matter for you. And ultimately, of course, Chair, the evidence that the inquiry hears and the way in which it is heard are matters for your judgment and discretion. You may consider that in light of all the submissions you've heard, an appropriate balance has been struck between institutional and non-institutional witnesses. The timetabling is also a matter for you. The inquiry has a busy programme of hearings across its 15 investigations. Since the start of this calendar year, it has held 6 preliminary hearings and 7 weeks of public hearings, notwithstanding the difficulties caused by the ongoing pandemic. While Ms Gallagher refers to further time being found for other hearings, there were specific situations in each case that required additional hearing time. As you'll recall, for the accountability and reparations hearing, a key witness was unavailable due to the pre-election period, when a general election was unexpectedly called last year. For the Roman Catholic investigation, again, a key witness was unable to attend due to ill health. And for the Spiros hearing earlier this year, additional time was required because you accepted that key witnesses were unable to attend to give evidence in May due to the pandemic. In all instances, the need for additional time was unavoidable and came at significant cost and disruption to the inquiry and court participants. And Chair, you'll be aware you have an obligation to act fairly, but also with regard to the need to avoid unnecessary cost. In conclusion, Chair, you may accept that the issues raised by this investigation could occupy many more days of hearing time, but ultimately a balance has to be struck and the evidence focused. And it's a matter for you to decide, Chair, whether the correct balance has been struck between the constraints I've set out and the need to test the most relevant evidence. And it's for you to consider the suggestions made by the court participants and the additional suggestion that I've made in response. So, Chair, those are all the observations I wish to make.
Thank you, Ms Hill. I will, of course, consider the submissions that have been made and make my decision. And I will ask the investigation lawyer to provide it to co-participants as soon as possible. I think we will now require a few minutes break to make the arrangements for hearing the first witness of the day.
That's right. Thank you, Chair.
We will return at 11:45. Thank you.